or good morning, everybody. Welcome to our webinar on C-92. We're very excited to have you all here, and we're very excited to partner with CCS on this awesome webinar. It's been a long time since we've done a webinar. So I'm Koren Lightning. I'm the legal director at Wahkohtowin Law and Governance Lodge, and we're zooming in here from Treaty 6. So and starting to see spring. Somebody said they saw a gopher the other day, so sure sign that spring is coming. So welcome, everybody, and I'll turn it over to Hadley to do the introductions.
Yeah, welcome. Really delighted to be here with this amazing panel. My name's Hadley Friedland. I'm the academic director of the Wahkohtowin Law and Governance Lodge. I'm going to do really short introductions. I'm just going to say names and position titles, and there's bios in the link, just so we save as much time as possible to hear from everybody, which we're all excited about. So we're welcoming Professor Naiomi Metallic, who's an associate professor at Dalhousie School of Law in Mi'kma'ki. Joshua Nichols, assistant professor at McGill Faculty of Law, originally hailing from BC and now in Montreal. Katherine Hensel, lawyer at Fogler Rubinoff, citizen of Secwepemc Nation, back in BC today. And Earl Stevenson, from Manitoba, in Manitoba, lawyer with Peguis Child and Family Services. And I do have to add this, Earl, and of course, my law school classmate, which is really fun. So welcome all of you, and we're really excited to hear your thoughts on this important decision. We're going to hear from each panelist, and then we're going to open it up for questions and have some questions. If you have questions, I believe you can write them in the Q&A, and then Koren and I will be watching that, and we might collate questions or ask them at the end, but you can add them as we're going along talking, so we're ready to roll at the end. So we're going to start with Naomi Metallic, who did argue this, who made submissions. Actually, 3 out of 4 of our panelists made submissions in this case. So I'm going to turn it over to you, Naomi, without further ado. And thank you. Start us off.
Oh, well, Ali O'Corn and Hadley, really nice to be able to be on this panel. I remember when Richard first asked, and it was before the decision came out, and you sort of, like, when people ask you that, you sort of put yourself in, what am I going to say when that happens? What will the future hold? And it was kind of getting a little long, right? 14 months, I think, was mentioned by Katherine a moment ago. Yeah, starting to get nervous. So I started to get nervous about this panel, but feel very good about the decision. I remember we got it, and we were on a sort of a lockdown for about an hour before, and as I was reading it and I got my special embargoed copy, I think my husband later said, like, don't go out gambling tonight because you have a terrible poker face or a terrible, as I was kind of saying, wow, as I was reading through it, quite surprised. I guess a few things I'll just pick up on, I'm sure others will too. I mean, the fact that this was a unanimous decision from the court, to me, I was not expecting it, given what I thought were sort of different camps that I was sort of observing and when I was watching the hearing. So the fact that they worked hard to come to a unanimous decision, to me, speaks very strongly about what they were trying to convey about the importance of this issue. And another thing sort of related to that, people have different views on, like, they sort of took a different pathway. They took section 9124 as opposed to section 35 to get at the result of upholding the legislation. A different path than the Quebec Court of Appeal did, who did really interesting things. And they didn't overturn the Quebec Court of Appeal. They just chose a different path for reasons, they said, of economy, that they didn't need to go there. One thing that, as we got up there, and there was 35 interveners and so many issues, and because Court of Appeal had put self-government on the table, there was a lot of focus on self-government. And, we were coming in from the Caring Society's point of view. And I think the one thing that we really wanted to emphasize is, these are all super important questions, but let's not forget the kids, that this is about children and families, and we cannot at the end of the day lose sight about this is why we're here, and that this legislation, although not perfect, is really is a mechanism to help families, right, and children and our communities. And that they use the language of legislative reconciliation, and I sort of use that in a paper that we got out before the decision. And so it does resonate that concern for Indigenous children and families, and the purpose of the act is really emphasized a lot in the decision. And so I was very happy to see that Jordan's principle is also emphasized in the decision, as well as this theme of reconciliation. I actually did a Control-Alt-Find, and there's something like 64 references to reconciliation. Like, it is sort of a dominating theme throughout the decision. And one that also surprised me was this theme that they emphasized, drawing from, I think, Josh, you were involved with this publication, but the braiding together, the UNDRIP braiding together of Indigenous, state, and international legal orders. That also got sort of brought into their I was shocked at that one, as well as how they just sort of casually brought in UNDRIP, right? Like, I think we're all a little gun shy and afraid, except for, I think it was the UBC, the Union of BC Indigenous Chiefs, but they had brought in, Gib Van Aert had spoken very directly about UNDRIP, and he didn't get the warmest reception from a couple of judges, and a little bit nervous about, like, oh geez, so to then sort of see in like paragraph 2 that they're just like, because of UNDRIPA, the act, it now applies in positive law in Canada, and away we go. And then citing it all over the decision. So that was a real surprise to me, but a very welcome one, I thought. So it's going to be interesting. I mean, there's things that they don't say, and sort of there was debates leading up to it about like the presumption of conformity and other stuff, and there's still things to unpack. But the fact that they emphasize the role of the UN Declaration and how it informs the legislation, how not only that, but how it has to inform the implementation of the legislation, I thought was really great to see. So very happy about those aspects of it. Lots of emphasis on TRC. So the TRC's sort of comment about, reconciliation being about mutual respect, and so bringing in a lot of those comments, that was really rich to see, as well as the TRC's comment that the UN Declaration has to be the framework for reconciliation, and emphasizing that and seemingly recognizing that. So that, I think, are all great things that can be built upon. Beyond that, the one area that I was quite pleasantly surprised was the work that they brought in with the honor of the Crown, and using Canada's affirmation of the inherent right to self-government. So I thought it was a neat way to essentially, they didn't want to get into the substance of, the underpinning of the act on Section 35 based on how the Court of Appeal dealt with it. But they still did some really important things with the right to self-government, which is to say, like, the affirmation is more than just, we said it, that's nice, right? Like, the way I sort of have said it in different talks that I've done is that it's essentially like, if you're going to talk the talk, you have to walk the walk. So that's the hook where they brought in the honor of the Crown, to say that, now Canada is bound, right? Well, they say that all the Crown is bound, and there's a little bit of uncertainty about who and how the Crowns are, well, I think it's not as uncertain, perhaps. There's a great article coming out by Rob Hamilton soon by A-Blog that's sort of unpacking it, but, the Crown is bound. That includes the provincial Crown, and we can talk more about that. But this idea that, the Crowns are bound in the future work of implementing C-92, so that they have to walk the talk, and there's going, the honor of the Crown, the obligation to diligently fulfill promises is now sort of invoked, and the court brought it up I think essentially of their own motion. I don't remember seeing any of the parties specifically make that argument. And I thought it was pretty clever argument, right? So this is how the hook. So it's not like Canada can just pass this and then go along its merry way and pretend that it never did, or say things at negotiation tables that are inconsistent with the recognition of the inherent right, or other things in the legislation. So they've given us an important sort of standard, I would say, in using the honor of the crown and the duty to diligently and fulfill promises, to require more and ask more, and sort of a mechanism to hold the crowns accountable. And maybe the sort of last thing I'll say before letting other folks talk is that that part of the decision, the honor of the crown and the duty to diligently fulfill promises, that's going to be sort of up for examination again in another case going to the Supreme Court in April called Dominic, which is about a First Nation in Quebec that has a self-administered policing agreement that has been chronically underfunded. I mean, every service area, as we know, in relation to First Nations is chronically underfunded, and we've seen some Canadian Human Rights Tribunal decisions that have affirmed that. But in this case, the First Nation also brought a complaint to the Quebec Superior Court, and then that went to the Quebec Court of Appeal, that alleged that chronic underfunding was also inconsistent with the honor of the crown and the fiduciary duty. And the Quebec Court of Appeal picked up the honor of the crown piece and the duty to diligently fulfill promises, and say that there was a commitment made in the First Nations policing policy to fund this on the basis of ensuring that First Nations folks have policing services that are of similar quality to other communities and meet their needs. And they said that they had failed to diligently implement that promise in the funding agreements that they subsequently signed with the First Nations. And we know how these are. They're not negotiated, they're just imposed, and they're just arbitrary funding numbers. And the Court of Appeal said that's not sufficient. So this is now going to go up to the Supreme Court, and hopefully some of the groundwork that was laid in this case and some future more argumentation, hopefully drawing in UNDRIP as well, can help us, make sure that, this decision could be really important and helpful in thinking forward on things that are going to happen in terms of implementation on C-92 for sure. So those are the sort of things that we're looking at, and I'm at about 10 minutes, so I'm going to stop talking and pass it on to one of my wonderful colleagues.
Next, we have Josh.
Perfect, thank you. So one of the things I think that I'd like to focus on in this decision is how it contributes to our understanding of the doctrine of federalism, in particular Section 9124. A lot of us were wondering what would happen with Section 9124 in this decision. In Chilcotin Nation, the court said that the doctrine of interjurisdictional immunity would no longer apply, and that Aboriginal and treaty rights in Section 35 were no longer part of the core of federal authority under 9124. And that had introduced a lot of uncertainty as to what is the scope of legislative authority of the federal government, what is in the core of 9124. And our courts have a long history of ambiguity on this part, much like the United States. Actually, a lot of us had been looking at a case called Brackeen v. Haaland in the United States, had the same kind of fact pattern, federal legislation relating to child and family, and the relationship between federal, state, and tribal authority. And we saw that as possibly a forecasting of what our court could do. The majority there went a kind of kick the can down the road approach and said that the nature of congressional authority is enough to pass this law. It's broad but not untethered, which is very unhelpful because it doesn't tell us what the scope is. It just tells us not infinite. But Justice Gorsuch provided a very detailed concurrence that it specified that congressional authority in the United States had two prongs. One that was deeply problematic and related to race, and that should be removed from federal law, and that federal law should be specified that it was plenary when it faced a state, but when it faced a tribe, it could only legislate in their best interests and with their consent. And so we were hoping for something that would specify the nature of Canadian federal authority under 9124. And I think that in a somewhat, it's almost easy to miss what they do, but at paragraph 94, they state the jurisdiction provided for in section 9124 is broad in scope and relates first and foremost to what is called Indianness, in quotes, or indigeneity, that is, indigenous peoples as indigenous peoples. Now, this can be quite easy to miss because they don't cite any authority here. Actually, they cite authority for 9124 later on, and they refer to a Alaskan case from the 1970s, Natural Parents. And that's where the term Indianness comes from. So to understand that this is not just a terminological change, right? We have to understand what the term Indianness means. Because you could be assuming that they're just updating language in the sense that Indianness would track back to the 1867 language, whereas indigeneity tracks to the Declaration language. And so nothing changes, just the language. I would argue that that's mistaken. If you go to Natural Parents, you find that the term Indianness is used to refer to that aspect of federal authority that the provinces can't touch. It is the core of federal authority. Where that term comes from is two citations by Laskin to early 20th century Ontario criminal cases, R.V. Martin and R.V. Hill. They in turn cite a Canadian Pacific Railway Company case of the Privy Council from 1899. And so this is where we get what Indianness means. They state in that Privy Council case, the British North America Act gives legislative control of the Indian defendant qua Indian, which is another term of art that shows up in 9124, Indian qua Indian, to the Parliament of the Dominion. This language is consistent with St. Catherine's Milling, which says and characterizes the power of the federal government as legislative control over Indian affairs generally. Now, when we take that as what Indianness meant prior to this decision, and we relate that to indigenous peoples as indigenous peoples, the inclusion of the term peoples narrows the scope of that authority. And I would argue links up with what the Quebec Court of Appeal said in their version of this, which was the historical relationship between the Crown and Aboriginal peoples both before and after the Constitution Act 1867 establishes that Aboriginal peoples have always been recognized as peoples and not merely subjects. Right. And the language of Indianness and legislative control over Indian affairs generally refers to subjects. So by switching the language, I think they are doing some of the work of de-imperializing the 9124 language and specifying what exactly the federal government has legislative authority in relation to. By saying indigenous peoples as indigenous peoples, I believe they are pointing back to the Royal Proclamation relationship. And what Professor Chartrand had referred to in his work before as a treaty power, meaning 9124 provides the federal government with the authority to make, maintain, and repair treaty relationships with indigenous peoples, which would also indicate that they no longer would have the power necessary to legislate the Indian Act. Much of that would be ultra vires. So I think it's actually a fairly significant change in the law. And the way it bolts together with, as Professor Metallic was referring to, the honor of the crown and how legislative reconciliation will work is interesting, because when they say that the federal government has taken an undertaking to recognize that indigenous peoples have the right of self-government, they're saying that that triggers the honor of the crown. And that's quite interesting to me, because when I consider what would happen if a government came in and repealed this legislation, they might be able to repeal the legislation, but they can't repeal what they've triggered with recognizing the right of self-government, because that triggered the honor of the crown. That's not legislative, that's constitutional interpretation. So I think that some very significant moves that are kind of difficult to unpack unless you know the doctrine quite well have actually been made in this case. I was actually surprised that they didn't take the route of the majority in Brackeen and just say, like, it's broad enough for this, we're not going to say what the limits are. I think by saying indigenous peoples as indigenous peoples, they actually have begun to include limits in 9124. And so with that, hopefully not too technical, of a review, hopefully accessible to folks, I'll just pass it on.
All right, next we have Katherine.
Wahkohtowin, Katherine Hensel Inquest. As Koren or Hadley said, I can't remember. I am a citizen of the Secwepemc Nation. I'm coming to you from Secwepemc, but I'm based out of Toronto. And my practice group and I at our firm, we work with about 15 different communities and tribal councils, organizations on the inherent jurisdiction work. And operationalizing it and working under the federal act to get the coordination agreements in place. So we've everything from the initial engagement with communities as they decide whether, to what extent, and how they're going to move forward in exercising inherent jurisdiction. Although in the drafting, the research, consultation, oral history, and then moving towards either ratification or other enactment steps and coordination with other governments. We were at the Supreme Court of Canada hearing on behalf of the Nunavut Regional Corporation, with whom we'd just finished, we had a negotiator's draft. The Northwest Territories was taking the position that despite the fact that it's basically like a municipality, it's created by a federal statute, and that federal statute says that if federal laws or if territorial laws, Northwest Territory laws, are inconsistent with any federal law, then federal law prevails. And they were saying that they were like a province, so the paramountcy provisions in the federal act did not on the same basis that Quebec challenged, they were also taking the position that there was no federal paramountcy for them under 9124. Fortunately, the court, given its conclusions with respect to paramountcy, did not even have to address our intervention, which was, was fine. But it got us, we did get an advance copy, like Professor Metallic. We were, my colleague Christy Sang and I were, our client was in Ottawa that week, so we actually went to the lockup at the court. There were a few other lawyers there, which added a little bit to the drama. We had charts. I think we'd identified 15 different issues that could go different ways. And because we had so many clients who were waiting, not just the Nunavut Regional Corporation, and clients for whom it would have different impacts based on the stage they were at or the approach they were taking, we had flow charts and draft opinions, and we had it all ready to go in that, because we get the copy a couple hours or an hour and a half in advance. So we were there at the Supreme Court in the lockup room with 4 other lawyers, and much shouting in that room, I have to tell you. Naomi, I wished you were there actually, because there's shouting, and then also some agonized cry, or there's some invitations they seem like invitations in the decision. Provinces can always challenge this. It's constitutional, but you can still challenge it. And I'm like, that's unhelpful. But but we were surprised. Then we had to go across the street before we went to meet with our client. Once the decision was formally released, we had to go, because they kicked us out of the court, so we had to go to the Starbucks down the road to get all the other briefing notes out to the other 14 clients. And we found in the Starbucks a marked up copy of the confidential decision with annotations. So we just kept that and destroyed it for them. Yeah, there was a lot of drama. So it is a relief. It removes a lot of uncertainty, particularly as we move into the coordination phase and the fiscal arrangements that our clients and the communities are trying to really lock down the funding so they can fully operationalize. It's a huge, huge project. Even for small communities who have relatively few numbers of families and children and families who are requiring service, it's an enormous undertaking. To set up set up, operationalize, develop a service model in addition to the drafting of the law. So it was quite it's multifaceted and overwhelming. And the clients we work with that have made the most progress are treating it like they consider themselves to be under a time pressure. First of all, there's question about the approach, after 2025, the approach that Canada is going to take on the funding and with respect to this statute. So we need to get it systems operationalized and funding secured. That's the pressure, as well as the pressure that they're getting from their own communities as we go through the consultation and engagement and legislative drafting. There are high expectations from many communities that this will be delivered. That one of the communities that I work with, the Secwepemc community, they ratified their law on Wednesday, and we're already at the coordination table. When I first engaged with them, the chief, Kukbi and Kunipla, told me, do not ask for our stories. We've been telling our stories since 1980. Make a law out of them. Do not start from scratch. We have transcripts, we have recordings, we have reports, we have all sorts of analysis of our oral history and our stories upon which you should base this law. Get it done. Get it done. Get it done. So their law, we anticipate, will be coming into force. Gwyneth and Wakikwa will be coming into force in December of this year. And we also are working with the Algonquins of Pikwakanagan, and their law is coming into force April 19th of this year. So, the pressure is on, and it was heartening to see that the Supreme Court endorsed the acknowledgement of inherent jurisdiction. The court did say at several points, well, provinces can challenge this, but then the commentary elsewhere in the decision, throughout the decision, made it clear that they did not gave us a lot of, arguably obiter, but a lot of material upon which to refute any challenges. If and when you have a system that's operational, a law that's grounded in the actual inherent jurisdiction of the community with respect in their territory and with respect to their citizens, then and you've documented that process as well, so that it can be defended, its legitimacy can be defended. There is so much in that decision that that we can pick up the commentary of the court, the entire court, to defend if and when there are challenges. And the challenges we anticipate will come potentially from some provinces. We know which provinces they are. Professor Friedland and Koren are sitting in one of them, potentially. We'll see. As well as from families themselves, blended families, where non-Indigenous parents will suddenly find themselves the subject of Indigenous laws in a mandatory way that is not subject to their consent. And well, welcome to the club, because we are regularly the subject of laws that we did not choose and do not reflect our culture or citizenship. So that's our that. And I think I'm rolling to 10 minutes. Am I, Koren and Hadley? Probably. But happy to hear, and also I'm really looking forward to hearing from others and Naomi as well about those invitations in the decision, what to make of that. That this is all constitutional. The provinces can say it's not still or challenge it. So I got a little hung up on that. So Cookshem.
Thank you, Katherine. And now we have Earl.
Bonjour. Benaji Gadu, Disney Kam, Connect to them, Peguis and Dunji, Nun Gum. Yeah, this was a really interesting process to be involved in. Peguis Child Family Services was one of the interveners in this appeal, and one of our main arguments talked about the principles of reconciliation and how those principles of reconciliation were necessary with respect to constitutional interpretation of First Nation and Indigenous rights. So I won't get into that because the brief is online. It's available at the Supreme Court website. But what I'll talk about is something similar to what Professor Metallic had talked about earlier. And when we look at the Act itself, Bill C-92, we look at Section 7, talking about the Act is binding on both the provincial and federal crowns. Section 8, sub A, talks about that it affirms the inherent right of self-government. And then 18, sub 1, talks about the inherent right of self-government as well. So what these three sections talk about, or what they lead to, according to the Supreme Court, is that through these sections, the honor of the Crown is engaged, and that's recognized at paragraph 63 of the decision. And those three sections lead to what they would presume would be the goal of reconciliation for those issues. At paragraph 60 of the decision, it talks about, and I'm going to directly quote, "These legislative affirmations are very meaningful on the ground where issues related to the well-being of children are decided. By setting out its understanding of the scope of this constitutional provision in Section 18, sub 1 of the Act, Parliament undertakes to act as though Indigenous peoples enjoy an inherent right of self-government in relation to child and family services. Moreover, by making this affirmation expressly binding on the Crowns through Section 7, Parliament ensures that the Crown also undertakes to act in accordance with its position that this right of self-government was recognized." So again, as mentioned earlier by Professor Metallic, this is very important when you're at the table in terms of ensuring both the feds and the province understand the role they have to meet and the duties they have to meet with respect to being at the table and fulfilling that honor the Crown obligation. And similarly, Professor Metallic talked about the Dominique case. So it was two cases. One went through the Canadian Human Rights Tribunal, which was Dominique, and then the second went through the Quebec Superior Court, ultimately the Quebec Court of Appeal. And the Quebec Court of Appeal citation is 2022 QCCA 1699. So that's the citation for the Quebec Court of Appeal decision. And one of the issues in that decision, which Professor Metallic talked about, was the honor of the Crown. And the Quebec Court of Appeal decision at paragraph 49 asked the question, and I quote, "Does the principle of the honor of the Crown, which is binding on both the federal Crown and the provincial Crown, come into play each time the Crown contracts with First Nations?" So again, very important when you're at the table on a coordination agreement in terms of making sure that the honor of the Crown obligations are met by both, again, the feds and the province. So this Quebec Court of Appeal decision basically stated that by failing to properly fund First Nations police services in a manner that allowed for the same quality of services as provided to non-Indigenous communities, both Crowns breached their duties to act honorably. So again, that's at paragraph 118 of the Quebec Court of Appeal decision. So when you're at that coordination agreement, you have to ensure that your social service requirements in terms of funding are met and have to be met. And a decision like this certainly is supportive of seeking those proper and requisite funding for those services that you need to provide. And if we go back to the Supreme Court of Canada decision, the legislative affirmation of that inherent right to self-government has that constitutional status. And with that, and from that premise, and from a jurisdictional standpoint, this right includes jurisdiction of Indigenous governing bodies in relation to child family services, which also engages that honor of the Crown. So again, that's at paragraph 64 of the Supreme Court decision. And as Professor Metallic has indicated, this decision from the Quebec Court of Appeal will be heard next month in April. So again, that's something we have to keep our eyes and ears open for in terms of how this Supreme Court's going to treat this decision. I want to talk a little bit about Section 20 sub 1 and 20 sub 2 of the Act, because those are two different paths to implementing your First Nation or Indigenous legislation. So 20 sub 1 talks about providing notice of your legislative intent to enact your law, whereas 20 sub 2 talks about submitting a request to the federal and provincial governments to enter into coordination agreement discussions for the implementation of your law. For the record, Peguis First Nation and Peguis Child Family Services, we have been implementing our law called the Honoring Our Children, Families, and Nation Act for over 2 years now. Our law came into force as federal law on January 20th, 2022. So actually January 21, 2022. So we've been implementing our law for over 2 years now, and I can provide some highlights later on if I don't run out of time, but for now, 20 sub 1 and 20 sub 2. When you look at that, and then you have to also consider 20 sub 3, which is kind of talks about sections 21 and 22 of the Act would apply in respect of an Indigenous group, community, or people on whose behalf an Indigenous governing body has A, entered into a coordination agreement, or B, has not entered into a coordination agreement, but have made reasonable efforts within a year. So, so what it talks about is the paramountcy provisions and the force of federal law provisions, would they come into play with respect to a law under a coordination agreement? Yes, they would. Now, the courts have talked about 20 sub 1 and whether or not these two mechanisms of federal paramountcy and force of federal law come into play with respect to a law created or implemented under 20 sub 1, which is that notice of legislative intent. The courts have been silent on that point with respect to whether or not, you know, that path would engage that those two sections, right? Paramountcy sections and the force of federal law section. So it's very interesting in terms of whether or not the courts, or how the courts would be treating that situation when it's not expressly stated with respect to 20 sub 1 notice of legislative intent laws. So I've had meetings with other nations across, throughout Manitoba and across Canada about the implementation, and I kind of steer them towards the coordination agreement process because the courts have an understanding that those laws will be paramount if there's any conflict or inconsistency with any provincial or territorial law. So I kind of, give them a push towards the 20 sub 2 process as opposed to the 20 sub 1 path. And when you look at the ISC website, Indigenous Services Canada website, on the notices that they have received, there have been 53 notices received with respect to the intent to exercise legislative authority pursuant to 20 sub 1. Meanwhile, there's been 38 notices or requests to enter into a coordination agreement pursuant to 20 sub 2. Now, currently, according to that website, there's 10 laws in force pursuant to 20 sub 2, while there's no law in force, according to my review of the website, pursuant to 20 sub 1. So quite interesting in terms of what's passed. Obviously I'm recommending in terms of what nations should enter into with respect to the coordination agreement route. Now, from the Quebec Court of Appeal reference, they did mention that when Indigenous peoples choose to exercise their legislative authority under 20 sub 1, it follows that 20 sub 3, that pursuant to 20 sub 3, their laws will not enjoy the protection and benefits set out in sections 21 and 22. So we have the Court of Appeal from Quebec stating that a 20 sub 1 law may not have the benefits of federal paramountcy or force of federal law. So, and that finding, and although it's likely over, it wasn't disturbed either at the Supreme Court of Canada. So we have to be careful in terms of how its future treatment might be considered by a province or by a territory as to whether or not a 20 sub 1 law could be challenged as to whether or not they have paramountcy or force of federal law. I also want to talk about territoriality a bit, because the scope of our law is national. And during the coordination agreement discussions, at one event only during a meeting, Canada raised the point that if you want your law to be national in scope, then Peguis, you have to enter into a coordination agreement with each and every province and territory for your law to be national. We said, absolutely not. Bill C-92 does not state that, does not require that, does not outline that whatsoever. Therefore, They presented us with a policy. We stated your policy on that point is unlawful, and it's not mandatory with respect to us to accede to your policy document. As a result, that ended the discussion, and we're of the position that our law applies national in scope with respect to our inherent right and our Indigenous legal traditions. So our members live across Canada, and our members are available to utilize our services pursuant to our law, the scope of our law. So, and that's what we've been doing. We've been considering that for our members when they request services from us based on our law, based on the implementation of what we're doing. So, from our perspective, when Canada makes a position of that part, it doesn't follow with respect to its own federal law when you talk about territoriality. And the Quebec Court of Appeal decision talked about territoriality very briefly, but they did say that Indigenous laws, content, and scope may be freely determined at paragraph 2 and 250 of the decision. And at footnote 278 of the Quebec Court of Appeal decision, they delve into this point a little bit further, noting that the scope of Aboriginal laws is not territorially limited, but may attach to the very individuals who make up the Indigenous peoples and follow them wherever they reside in Canada. So again, they note that this is a kind of a rationale personae by reason of the person attachment. So an IGB may decide that its law applies to its members it represents who are located beyond its normal territory and even outside its province. So again, that's the position that we've taken during the coordination agreement process, and we haven't moved from that position whatsoever. Now, similarly, we're in the process of going to be creating our own court or tribunal, and we recognize and acknowledge that the federal court is a traveling court, so it has sittings throughout Canada, and that's a similar approach that we're going to take when it comes to us initializing and establishing our own court and tribunal process. If there's a matter with respect to a family in Alberta, our tribunal, our court will travel to Alberta and hear the matter there and make a decision when that needs to occur. So, like the federal court, we'll be a traveling court. So, I'm almost out of time, but I want to give you some highlights quickly. As of October 31st, 2023, we have 214 children in care. When I started here at Peguis CFS in December 2019, we had 452 children in care. So there's been a substantial decrease in children in care with respect to the services that we provide. And that's basically because, as our law requires and as Bill C-92 requires, preventative measures is the first priority, and that's the approach we've been taking on prevention services. We have a 109 extension of service agreements for our youth from ages 18 to 26. We have 57 customary care agreements to date. We have 7 agreements with minors, so ages between 16 and 18. These agreements with minors, if they're quasi-independent, then we can support them in that sense. We have 22 court orders under our law, honoring our Children, Families, and Nation Act, not the Manitoba CFS Act. So that's since implementation. And these orders are temporary orders or continuing temporary orders. There's no more permanent orders under our law. We do not seek permanent orders because permanent orders are termination of parental rights, and that's something that we absolutely do not want to do. We are doing more and more rescinding of permanent orders so that we can enter into supported subsidized guardianship with extended family and helping to raise, our children. And in 2023, there were only 9 apprehensions from our agency. And that's quite unheard of, if I'm being honest, because most agencies, there's multiple apprehensions per month. But in our situation, we've only apprehended 9 children in 2023. And I encourage our audience members to visit our website, peguiscfs.ca. There's a lot of information there about our program and services. Our regulations are online as well, so we're very open to sharing information. So we certainly invite people to visit our website. Lastly, I wish to acknowledge, the audience members. There's family and friends in the audience, so I appreciate their participation as well, and as well as Professor John Burroughs is there. So I certainly acknowledge John and his influence in the work that we've done here. Miigwech.
Thank you so much, everyone.